Hi, and welcome to Talking Legal Episodes. I'm Praveen Gautam. I help entrepreneurs and enterprises to build a digital brand and monetize it. We are live in Facebook and LinkedIn. And by the way, guys, if you are new, we'd love to know and just type new here. And if you have been watching these episodes for a while, thanks for being. Just sit back and join us for next 10 minutes or so. And we'll be talking about force majeure in building and construction industry. All right. And on that note, feel free to comments. I'll just or share this post as well to your wider community. All right, Len, great to have you today.
Yeah, thank you, Prabhan. It's great to be here again. Always a pleasure.
Yeah. Len, you have a 25 years of experience in liaising with QBCC from license applications to resolutions of million-dollar building and constructions disputes. Yeah.
Yes.
So you position as a trusted building and construction solicitor. And obviously the last time we deal with the force majeure in 2 episodes, and this is we are revisiting it. And obviously all the viewers who have been giving us the feedback, thank you for that, because we understand. So just on that note is, given we have looked at the delay and force majeure from primarily of building perspective, is this a situation different from other side of contract, like for the developer or the principal, Len?
No, not really, Prabhan. I suppose, but there are some. I would suggest different perspectives and from being on the other side of the contract. So, if a force majeure clause is included in the contract, its operation is no different for the developer or the builder. Of course, the developer or the principal will always have a different view. Their focus is to obviously complete a project. They will, quite often have obligations to financiers. But I think it's probably relevant that we just have a quick recap on what a force majeure clause is. So it's generally it's considered like an act of God, or a strike, or a shutout, or a pandemic. So the elements of it are generally it's occurred by nature or human elements. It cannot have reasonably been foreseen by the parties when they entered into the contract, and it must be outside of the control of the parties in that they could not have prevented it from happening. So if a force majeure clause has been included into a contract, and it is has a scope that's wide enough in relation to the current pandemic, then of course it needs to be looked at. But from one side of the fence being the builder is looking at it because he is probably experiencing some issues around supply of materials, etc. But from the developer's point of view, it's a completely different issue. The developer, as I was saying before, has obligations. Quite often the developer will have given undertakings to their financier. So it's a different point of view.
That's interesting. You said that. Obviously, that's a reflect to the different clientele for sure.
Yeah.
Now, does a developer then have to agree to a delay or enacting of a force majeure clause?
Well, I suppose each individual circumstance does turn on its own set of facts. So it's important, firstly, to and I probably revisit this quite a lot, but it's important in the first instance to just, if there has to be a force majeure clause in the contract, and then that particular clause has to operate in a particular fashion, or its operation needs to be reviewed. Now, if I'm acting for a developer, in the first instance, I would potentially be advising the client not to just necessarily rush out and agree to a force majeure. The parties should always think about the effects of enacting such a clause. So, common consequences of enacting a force majeure clause can include the suspension of contractual obligations, the exercising of liability for non-conformance, performance or delays, termination of the contract, extension of time, renegotiation of certain terms or certain contract remediation or governance measures. So any relief is often available also only for the duration of the force majeure event. So the parties will need to be mindful of any wrongful termination proceedings in a contract, and in the event that a party's right to terminate under a force majeure, if that's where they're going, is disputed. So it's not something that you enter into lightly, and from the developer's side of the fence, it's not something that you really want to enter into, because it changes the contractual landscape somewhat, and that could lead to potentially sort of unforeseen consequences. It can change the obligations and the rights, etc. So it's not something that you enter into blindly, and it's certainly something that needs to be carefully considered. And my first reaction, if I was advising a developer, would be to certainly slow down and not rush into such a situation. That's for sure.
Slow it down. That's a great insight. Then would that also means then can the developer rely upon their contract with the builder?
Most certainly they can rely upon their contract with the builder. I mean, I often think that we have a false sense of contractual obligations because of the comings and goings of everyone's favourite football team. It seems that contracts don't really mean a lot because today's coach is tomorrow's has-been, and contracts seem to be ripped up, and often people have the wrong idea about what a contract means. A contract is a legally binding agreement. It's a relationship that those parties have entered into, and they have given each other obligations, and they have taken on liabilities in relation to each other. So the developer can rely on the contract with the builder, and particularly if the contract does not allow for a force majeure clause, then the builder is realistically only able to ask for extensions of time, etc., that are for reasons that are covered under the contract and its terms. So if it's not something that is covered within the scope of the contract, then potentially the developer can and potentially would say, I'm sorry, I'm not accepting that extension of time or that request. Mr. Builder, you just need to crack on and get the work done.
Thank you, Len. I hope that's given a very good perspectives on the force measure. But by the way, guys, if you're just tuning in, we are talking about force measure in building and construction industry with our principal lawyer from Baker Watt, Len Watt. And if you feel free to like, share, and comments this video, and look forward to get the feedback. Now, let's then talk about what remedies are available to the developer, Len.
I think this is an important point. So the developer obviously is able to rely upon the contract. The timeframes within the contract are always important. Everybody involved in this area of industry has heard that time is of the essence, and certainly time is of the essence. So a contract allows a period of time for a particular work to be done. Outside of that time, then obviously there is a penalty on the builder for each day that he goes over time without having a valid extension of time granted. Now that is generally called liquidated damages, and it's a cost per day that the developer imposes upon the builder, and obviously at the end of the contract, these particular areas can often be quite controversial. But the idea being that for each day that the builder's late, the developer is entitled to be paid at a preset amount. So, for example, we could say that for each day that the builder doesn't complete the project, the developer is entitled to, round figures, $1,000. And in the context of some projects, that's very low. when practical completion is finally reached and the final payment is being assessed, those days over the date for practical completion will be assessed and an amount deducted from the builder's final payment, which can often lead to disputes and to broader actions. But that's really sort of for another day. But Prabhan, as you know, I'm always a great believer in parties actually discussing these things before taking unnecessary action. And I again say that whilst the developer has a particular perspective, and it's a perspective that obviously is important, given that he'll have obligations to his financer. It's always worth trying to sort of see if there's a way that these things can be done and sorted out without having to, revert to, legal action, etc. Because that it benefits lawyers, but it doesn't necessarily benefit the parties to the contract.
Great point, Len. I mean, that's one of the things, your point of difference is not just the legal solution, but overall business solutions to help them, to guide them through that process. Now, that's a great insight, Len. I'm conscious with the time. Hope this episodes has been very clear for our viewers right now, especially with, for Force Majeure for principals and developers who are watching this right now through LinkedIn and Facebook. Feel free to comment and give a feedback and really what exactly you are facing it right now, what challenges you are facing in. So Len and his team can definitely help through. So if someone is watching this right now, Len, then what would be the best contact for you to get, for them to get in touch with you?
There's a number of ways, Prabhan. Obviously, info@beckerwatt.com.au. We are certainly, that's an email that is monitored, and anyone who comes through on that particular email will certainly be in contact with my team, and they'll certainly be talking to them. We have our 1300 @legal telephone number. Again, that number will come through to us, and we will certainly be able to assist and hopefully solve the problems that come up. And also on our website, www.beckerwatt.com.au, you can certainly book an appointment through that particular avenue as well.
Thank you, Len. Once again, thank you so much for your time, and all the details are right below. And look forward to hearing your feedback and see how Len and his expert team can help you assist this. Thanks for watching, guys. Take care. Bye for now.
Thank you very much. Bye bye.